Mr. Oddie.
My lords, my lady, I've addressed the first two questions as we see them, engagement and
Yes.
correct test. I was going to turn to the third question, application of the tests to the two sections of the State Immunity Act under challenge. And the critical question here on our submission is applying an appropriate margin of appreciation. Are the restrictions imposed by Section 16(1)(a) and Section 4(2)(b) required by international law, or do they reflect generally recognised rules of public international law on state immunity? And I'd like to take the provisions in the same order as the Court of Appeal did, dealing with Section 16 first, the more far-reaching provision, and Section 4(2)(b) second. So Section 16(1)(a) first. This is addressed by the Court of Appeal in its judgment at paragraphs 31 to 53, and by the Secretary of State in paragraphs 124 to 141 of his printed case, and by us in paragraphs 26 to 79 of our printed case. The effect of Section 16 is to leave untouched, so far as all embassy employees are concerned, the absolute immunity for states provided for in Section 1 of the State Immunity Act. As the Court of Appeal held at paragraph 47 of its judgment, it has been described in quite striking terms by one of the leading academic commentators, a commentator relied upon by the United Kingdom in its previous submissions to Strasbourg in this area, Professor Garnett. As the Court of Appeal pointed out, in an article published by Professor Garnett as long ago as 2005, he said that under Section 16, the rights of all embassy and consular employees are effectively eviscerated, and that the United Kingdom's position was appropriately characterised as the harshest in the developed world. Now, that characterisation of the United Kingdom's position, as evidenced by Section 16, is, we would respectfully submit, an entirely fair one, notwithstanding its striking terms. And it is, to put it mildly, not a promising starting point for the Secretary of State in seeking to establish that Section 16 is a necessary reflection of an obligation owed under international law, or that it is reflective of generally accepted principles or rules of public international law. And in fact, as we have sought to show in our printed case, any consideration of the relevant materials shows that it is not any such thing. That view is, we submit, supported by each of the sources of international law identified in Article 38 of the Statute of the International Court of Justice, and as the Court of Appeal's judgment clearly demonstrates. There is no support for the argument that Section 16 reflects an international obligation in international conventions. There is no support for it in international custom in the form of judicial decisions, or save for the three exceptions of South Africa, Pakistan, and Malawi, domestic legislation, and there is no support for it in academic writings. Now, the exercise of seeing how Section 16 measures up, as I say, is dealt with in detail by us at 26 to 79 of our printed case, and at paragraph 26, we have sought to draw together the key findings of the Court of Appeal in that regard. And we then start to address the position as reflected in international conventions from paragraph 28 onwards. But as the Court of Appeal held, Section 16 was appropriately characterised as a blanket provision, paragraph 31 of the judgment. It is possible, as the Court of Appeal illustrated at paragraph 32, that even as at 1978, the Act had gone further than the common law on state immunity required. It is quite clear that there is nothing in Article 11 of the UN Convention to support a provision as broad as Section 16, as the Court of Appeal pointed out at paragraph 40. And against that background, as the Court of Appeal found at paragraph 46, it was impossible to conclude that there was any rule of international law which required a grant of immunity of such breadth. That conclusion, as we've seen already at paragraph 47 of the Court of Appeal's judgment, was supported by Professor Garnett's analysis, and it was further supported by the Court of Justice's decision in Mahamdir, which I'm going to come to in some detail. The Court of Appeal held that the Bâle Convention did not require a provision of that breadth. That's paragraph 34 and 56 of the Court's judgment. And it concluded at paragraph 53 that it inevitably followed that Section 16 was incompatible with Article 6 of the Convention. Now, we've set out earlier on in our printed case, and well familiar to the Court, I know, but we've set out the provisions of Article 38 of the International Court of Justice's statute at footnote 3 of our printed case. Footnote 2 on page 1. And I'd like to look at each of those in turn to see whether any of them show that Section 16 is required as a matter of international law, or any of them show that it reflects generally accepted rules of international law. International conventions first. There are two that are relied upon for this purpose by the Secretary of State: the Bâle Convention and the Vienna Convention on Diplomatic Relations, and for this purpose, particularly Article 7 of that convention relating to freedom of appointment. And it's said at paragraph 124 of the Secretary of State's printed case that Section 16 reflects Article 32 of the Bâle Convention, and at paragraph 130 that adjudicating on claims in respect of dismissal from employment as a member of the mission would conflict with the freedom of appointment guaranteed by Article 7 of the Vienna Convention. Now, there are a series of fundamental problems with that approach, as we have sought to set out at paragraphs 77 to 79 of our printed case. And taking the Bâle Convention first, and some of these points I previewed in my opening submissions this morning. Taking the Bâle Convention first, there's first of all the obvious point that that convention is itself 45 years old, and it has so far failed to attract the support of more than 8 of the 47 Council of Europe members. Secondly, as the Court of Appeal held at paragraph 34 of its judgment, Article 32 of the Bâle Convention is not the exact counterpart of Section 16 of the State Immunity Act. And Article 32 simply does not require a term of such breadth. This is the point we make at paragraph 79 of our printed case. The Bâle Convention is itself at Core Authorities 1, tab 2, MS 808. And as you see from MS 817, Article 32 simply says that the Convention, nothing in the present Convention shall affect privileges and immunities relating to the exercise of the functions of diplomatic missions and consular posts and of persons connected with them. On its face, it appears to do no more than seek to leave untouched whatever protections apply under the Vienna Convention, and indeed the Consular Convention. Section 16 goes very considerably further than that by reimposing the absolute immunity provided for by Section 1 of the State Immunity Act. It leaves all embassy employees entirely unprotected, whatever their level and whatever the circumstances. And we see that if we turn up the State Immunity Act itself, which is at the next tab, MS 821, core bundle tab 3,
Yep.
and 831, where we have section 16.
Yes.
If section 16 were the true analogue of Article 32 and was simply reflective of it, it would have stopped at the first semicolon. So that's the second point. The Court of Appeal was absolutely right to say that the provisions were materially different. The third point, again, as the Court of Appeal found at paragraph 34 of its judgment, as I mentioned this morning, and as we have pointed out at paragraph 100 of our printed case, the domestic law of 5 of the other 7 signatories to the Basel Convention is flat inconsistent with the idea that international law requires a provision as far-reaching as Section 16. Because 5 of those other 7 countries have case law showing that in certain circumstances embassy employment claims can proceed. And as to the other 2, again, as I mentioned this morning, Luxembourg and Cyprus, we simply don't have any material before the court. So the United Kingdom is alone as a signatory to the Basel Convention in contending that it requires a blanket provision of the kind that Section 16 is. So that's one of the conventions relied upon. The second convention relied upon is the Vienna Convention on Diplomatic Relations. And the Court of Appeal found at paragraph 35 of its judgment that Article 7 said nothing at all about immunity from proceedings of the kind in issue here. And we have Article 7 again in the same bundle, tab 1 of the core bundle 1. And it's all about freedom of appointment. And it's exactly the distinction that my Lord Lord Clerk raised in the course of yesterday afternoon, that that's a very different situation to freedom to dismiss anyone at whatever level, on whatever basis, in whatever circumstances. Now, in arguing that Article 7 of the Vienna Convention is of critical importance in this regard, the Secretary of State at paragraphs 29 and 134 of his printed case cites Denzer, the commentary on diplomatic law, and the reference that Professor Denzer makes to Article 7. Now, we deal with this in our printed case at paragraph 77.3, and the simple and short point is that Professor Denzer does not actually appear to suggest that Article 7 of the Convention would preclude claims of the type brought by my client, Miss Janah. And in particular, she appears to see no conflict at all between the provisions of Article 11 of the 2004 Convention and Article 7 of the 1961 Convention. And we get that from the express words that we've quoted that are missed out in the Secretary of State's citation of Denzer on page 55 of our printed case, where Professor Denzer says, Article 11 of the 2004 UN Convention is more than sufficient to safeguard the right of a sending state to free choice in the appointment and dismissal of staff of its diplomatic mission. So nothing in either of the two conventions that the Secretary of State has identified which gets remotely near showing Section 16 to be required by a source of that nature. The second source of international law set out in the ICJ statute is then custom, and I'd like to address both the 2004 Convention and the state practice materials before the court, region by region, in relation to domestic legislation and judicial decisions. The 2004 Convention first, we've addressed this at paragraphs 28 to 56 of our printed case, and the Court of Appeal addressed it at paragraphs 36 to 39. Now, before addressing its status, I would like to focus on three areas through which we say it provides, at the very least, powerful evidence of state practice. First, in its drafting history. Secondly, in its final content. And thirdly, in the means by which it was adopted by the General Assembly. Now, the drafting history is set out at paragraphs 48 to 56 of our printed case. And you will see from paragraphs 48 to 52 in particular that right from the beginning, as early as 1983, there was no proposal for an absolute blanket bar on claims by all embassy employees of the kind which Section 16 achieves. Now, on that, in fairness to the Secretary of State, there is a reference, a passing reference in Fogarty, which suggests something to the contrary, which I'd like to go back to, if I may. Fogarty is at Core Bundle 2, tab 14, and the material passage here is at paragraph 19 on page 1379, the last subparagraph of paragraph 19. And this was dealing with the draft articles of 1991. And the passage that Ms. Stein drew attention to reads as follows: although there is no explicit reference to employment at diplomatic or consular missions in these provisions, that's referring to the 1991 draft articles, the commentary indicates that the latter exception was intended to apply in such a context, and that all employees at such missions would be precluded from bringing suit on the basis of state immunity. Now, if one actually looks at what the commentary says, it doesn't go nearly that far. And you find the commentary itself at Bundle 8.
Which paragraph were you reading from in Fogarty? I'm sorry,
my Lord. It was paragraph 19, the last sub-paragraph of that.
The last sentence, basically.
Oh, I see. Yes, I see. Thank you. Yep. Thank you.
And so if you then go to the commentary itself,
Yep.
which that's purporting to reflect,
Yep.
you have that at bundle A19, page 6673 to 4.
Oh, yes.
And if you look at what subparagraph 9 towards the foot of the right-hand column on 6673 says, it says this: paragraph 2A enunciates the rule of immunity for the engagement of government employees of rank whose functions are closely related to the exercise of governmental authority. Examples of such employees are private secretaries, code clerks, interpreters, translators, and other persons entrusted with functions related to state security or basic interests of the state. Officials of established accreditation are, of course, covered by this subparagraph. Proceedings relating to their contracts of employment will not be allowed to be instituted or entertained before the courts of the state of the forum. But it says nothing at all about domestic staff or service staff. And we know from the Vienna Convention that the only people who are described as having accreditation are heads of mission. And this is the point I flagged this morning. And it's entirely unsurprising that heads of mission aren't able to sue in the forum state on a whole number of grounds. They'll very likely be part of the civil service, but in any event, they're going to be completely bound up with sovereign function in a way that cannot remotely realistically apply to people in my clients.
Where do we get the fact that it's heads of mission? I thought it was diplomatic staff as well.
Well, it's the reference to accredited,
Right.
my lord. And then if you go to the Vienna Convention, the only people who are described as having accreditation are heads of mission. We get that from Articles 5 and 6. I don't want, of course, don't want to take a bad point, and if there is some other source suggesting accreditation applies to diplomatic staff, so be it, but it doesn't.
I thought that accreditation simply meant anybody who required the agrément of the receiving state.
Well, my lord, we say it's accreditation in the sense reflected in the Vienna Convention, and so should be the heads of mission, or at most diplomatic staff. Certainly shouldn't extend to service staff. So the point that I started with there, and the point that we make at paragraphs 48 to 52, remains a good one, notwithstanding that passing reference in Fogarty. Right from the beginning, as early as 1983, there is not a hint of a proposal for an absolute blanket bar on all embassy employees. The more accurate statement, perhaps, of the law as it stood at the time of Fogarty is that was set out in the concurring judgment in Fogarty, which certainly Mr. Justice Langstaff, at first instance in these proceedings, seemed to favour. And the reference to that concurring opinion as to the state of international
Page
law.
1386.
Exactly, my lord, yes.
Yep.
012 to 13.
Thank you.
And for my lord's reference, Mr. Justice Langstaff on that is MS 472 at paragraph 24.
Thank you very much.
So we then go on in our printed case at paragraphs 54.1 to 54.2, having dealt with the position from 1983 onwards, to deal with the position from 1991 to 2004. And we make the point there that, again, there was virtually no support for a blanket ban on claims by all embassy employees. And it was only those who performed functions closely related to the exercise of governmental authority who were intended to face a situation of immunity. And as the quote at paragraph 54.2 of the printed case shows, the General Assembly's Sixth Committee, which is, of course, the primary committee responsible for legal affairs at the General Assembly, upon which all member states are entitled to representation, considered a narrow list of those whose claims could be barred to reflect state practice, in the words that we've underlined in the quote at 54.2. And as paragraph 55 points out, when the Sixth Committee, responsible in tandem with the ILC working group for work on the Convention, came to vote on the matter, no state representative voted against allowing claims by low-level employees. So paragraph 56 summarises the overall position in terms of state practice as it can be viewed through the prism of the negotiation process for the 2004 Convention. And it's against that background and that properly detailed background, we say, that the Secretary of State's submissions on the drafting history and suggestions that there were some major issues of controversy or major areas of disagreement are to be tested. And it comes back to the broader headline point I made this morning, that there may have been diversity of view, yes, but there's never been a material diversity of view, such as could impact on the outcome of this case. Now, as to the content of what then results in the form of the Convention itself, it, of course, contains no blanket ban, as Article 11 vividly illustrates, and as we've pointed out at paragraphs 28 and 29. And we entirely stand by the submission in the first line of paragraph 28 that Ms. Janah's claim would be permitted to proceed by reference to Article 11 of the 2004 Convention. And we stand by that, notwithstanding the submissions that were made yesterday about Article 11.2b, little Roman 4 of the 2004 Convention. And you will recall that this was a matter that the Court of Appeal dealt with at paragraph 38 of its judgment, because a submission to the same effect about 11.2b4 was advanced by Libya below. And the Court of Appeal, we say, was correct to reject it for the reasons it gave at paragraph 38. That's MS 439, the Court of Appeal's judgment.
That's difficult, isn't it? Because they seem to think what they seem to be doing is correcting the text of the article by reference to the travaux preparatoires, which is not normally regarded as a legitimate use of the travaux. I mean, it looks as if it's rather a mystery what happened between the discussions and the approval of the final text, but the final text doesn't seem to say what the travaux say.
No, the original text, we do get some further help on this. You'll see that the Court of Appeal does cite Folkes and Keefe on this, and indeed what Folkes and O'Keefe say about the travaux. And they show that the original drafting of this provision was intended to cover a residual group of persons who might be attending, for example, international conferences. And we get that from Folkes and O'Keefe at Core Bundle 3, paragraph 25, tab 25, MS 1775.
Well, it may have been, but I mean, that's quite plainly not what the article says. The only limitation on little Roman 4 is the exception that arises from Article 37 of the Vienna Convention, which is that diplomatic immunity isn't enjoyed by permanent residents or nationals of the receiving state. I mean, it may not have been what the Travo suggested was intended, but it's hard to see how you get anything else out of the language.
The way we get out of it, my lord, and without going back over all the case law on why you look at the Travo, if one focuses solely on the convention itself for the moment, if that were right as a construction of Little Roman 4, then one wouldn't need any of Little 1 to 3 above, because all of those people would enjoy diplomatic immunity inevitably. And one could have simply a provision saying any person enjoying diplomatic immunity.
Well, that's recognised in Little Roman 4 when it refers to any other person enjoying diplomatic immunity. So it's those three and anyone else enjoying a corresponding immunity. But how would you construe 4? How would you express 4 in a way that reflected the submission that you're making?
By implication of the words in the earlier drafts, namely such as persons attending international conferences. And the advantage of that approach would be that it wouldn't make a nonsense of the choice between the two lists of people to include in the earlier provisions.
But paragraph 2 of Article 11 is only concerned with employees of a mission.
Well, it's concerned with all employees of a state. And there was then debate about who to specify in terms of mission employees. And the debate was between including Little Roman 1 to 3 and including a full list of everyone down to service staff. And the unequivocal view arrived at was to go for the Little Roman 1 to 3 approach. And that choice would be rendered a nonsense if Little Roman 4 were given the broad meaning that's contended for.
So why do you say that the words were excised out of the earlier draft?
I don't know why they were excised, my lord, but I can give them a perfectly adequate meaning by reference to the earlier draft. We don't have anything even in the Travo as to why they were excised. But what we do have is what we submit to be authority of at least a persuasive effect from the leading commentators on this area, indicating that it was not intended to exclude all domestic employees.
So that's O'Keefe, is it?
That's O'Keefe, yeah. And if one's taking a pure Vienna Convention on the Law of Treaties approach, we have two reference points which support our approach. We say, one, look at other provisions in the Convention and see how they fit together. And two, look at the overall intended purpose of the Convention. And for that, and the third one as well, you can look at the Travo to confirm the meaning you've arrived at if you want to. So nothing there, we say, on analysis, to displace the Court of Appeal's correct approach to 11.2b4. And that leaves, so that's content of the Convention, and nothing in the content of the Convention requiring a blanket bar. As to method of adoption, the Convention was adopted without a vote by the General Assembly, and that is a procedure which is only available as a matter of United Nations procedural law if no state objects and if no state wishes there to be a vote. And that's the point we've made at paragraphs 41 and 45 of our printed case. And that's not just an arid point about General Assembly and United Nations procedural provisions, as we know from the fact that the United Kingdom itself relied upon the absence of a vote prior to adoption in contending that the European Court should treat the 2004 Convention as reflecting customary international law in the Jones litigation. And we've made that point at paragraph 41 of our printed case, and you see the United Kingdom's submissions in Jones at A20, paragraph tab 247, MS 7188. And it's one of the slight ironies of this litigation that in other contexts, the United Kingdom is very keen to commend the high status of the 2004 Convention, and indeed to cite the much criticised QDAC decision in support of that proposition. And that was the stance it took in Jones, as I've said, at page MS 7188, emphasising the principal purpose of the Convention being codification. Now, on that question of status, we've addressed that at paragraphs 31 to 47 of Ms. Janah's printed case. And I don't want to take too much time over it because it's not necessary for Ms. Janah to succeed, but I would like to emphasise three matters from the points we've set out there. The first is that on any view of the authorities, the work of the International Law Commission, the work of the General Assembly's Sixth Committee, and the content of the Convention must be treated as being of great weight in determining current international thinking on the true extent of state immunity. And as to this, I draw attention to the observations to that effect from the House of Lords in Jones, which we've set out at paragraphs 31 and 32, and the views of the International Court of Justice that we've set out at paragraph 34.
Yes.
The second
It's
point...
undoubtedly right in the particular context with which both the ICJ and the House of Lords in Jones were concerned. But does it follow that everything in the Convention is to be regarded as a statement of customary international law?
No, it doesn't, my Lord, and that's why I didn't put it any higher than saying that they're entitled to be given weight.
I see.
And I fully acknowledge the observations by Lord Mance in Belhadge, where he emphasised the importance of context. As to that, we do say, though, firstly, we don't need to go as far as to contend that the entirety of Article 11 is customary international law to win by any means. The boot, as I've been seeking to submit already, is very much on the other foot in terms of the international law analysis. We are entitled to say, notwithstanding the context of Jones and the ICJ case, and notwithstanding Lord Mance's observations, that the Convention is a powerful source to be weighed in the balance. And we are entitled to say that the European Court of Human Rights has certainly treated it as such, and indeed has gone further and to treat it formally as representative of customary international law. And on that point also, it's perhaps worth flagging that Professor Garnett, in his most recent article, which post-dated the Court of Appeal's judgment in these proceedings, has expressed the view that at least Article 11.1 and 2a are reflective of customary international law. And he has joined with the criticism of the Court of Appeal of some of the reasoning in QDAC, but he has essentially expressed the view, which we submit is correct, that it's arrived at the right destination, at least so far.
Do we have that?
You do, my Lord. You have it in Core Bundle 3, tab 26, and the particular passages that he deals with this at are MS 1795 to 1805.
Thank you. Yep. Well, we don't have to look that
You
up.
don't have to look at that, but it may be worth noting the reference.
1795 to 1805.
That's it,
Thank you
my
very
lord,
much.
yes.
Yep,
So that was
okay.
my second point on the convention on status of the convention, that it's at least highly persuasive authority, C. Jones, notwithstanding the qualification from Lord Mance in Belhadge. And the third point was that there is particular force to the International Law Commission's work when it has been endorsed by the General Assembly of the United Nations. And we get that from the points we make at paragraphs 43 to 44 of the printed case.
Thank you.
Before leaving the convention, I'd just like also, if I may, just to address one point, so our position on it is clear. The question was canvassed in argument during the course of yesterday afternoon as to whether, I think by my Lord Sumption, as to whether Article 11 was essentially setting aside a distinction between iurae imperii and iurae gestionis and adopting a quite different approach. As to that, we say, our submission is that that is not the case, and that iurae imperii versus iurae gestionis is very much at the heart of Article 11. And we get that from Article 11.2a, with its focus on an employee being recruited to perform particular functions in the exercise of governmental authority. We get it from 2b, with the list of individuals, diplomatic agent, consular officer, member of the diplomatic staff, and my construction of Little Roman 4, who will not be able to avoid immunity. And we get that from the provision relating to recruitment, renewal, and reinstatement, because claims of that nature may inevitably touch upon sovereign issues of management and so forth. So it is, on its face, very much still at the heart of Article 11, and it's certainly the case that that is how Strasbourg has seen Article 11 too, even setting aside for the moment the question as to whether or not Strasbourg was right either in route or destination in characterising the 2004 Convention as customary international law. It has made a series of statements in which it has treated the Convention as inspired by the ius imperii, ius gestionis distinction. And we get that from QDAC, for example, at MS 1409, paragraph 70, this is the passage I've already shown the court about burden of proof, with the focus upon the failure by the Lithuanian court or government to show how duties could objectively be related to sovereign interests of the Polish government. Yep. We get it perhaps most clearly from Saber El Lyle, the second Grand Chamber decision at paragraph 18, where having cited page MS 1420, having cited state immunity from jurisdiction and the 2004 Convention, the court goes on to say the principle is based on the distinction between iurae imperii and iurae gestionis.
Sorry, what page was that, MS?
MS 1420, my lord, paragraph 18, the last sentence.
Not in... Okay, I see.
And we have similar references, I don't need to turn them up, but I'll provide them to the court if I may, in Wallishauser, paragraph 30, MS 1442, Radunovic, paragraph 41, MS 1525, and Olejnikov, paragraph 61, MS 4002. So all of that rather supports, we say, the analysis that you'll see that Professor Garnett has followed in his 2015 article, to the effect that whatever points may be made about the route by which it's arrived at that position, Strasbourg has settled on the correct destination, by reference to Jure imperi, Jure gestionis. So that's the convention element of state practice. I'd like to look at state practice outside the context of the negotiation and finalisation and adoption of that convention next. And this is addressed by us at paragraphs 57 through to 62 of the printed case. And we have, as I said earlier, addressed two principal sources of state practice: domestic judgments and domestic legislation. And we've referred to their importance and the ILC's views on their importance at paragraphs 57 and 58. And I'll come on separately to Ms. Staine's principal point about state assertions of immunity separately. And what we've then, and I should say the Court of Appeal's core conclusion on this is itself set out at paragraph 58 of its judgment. I'm sorry, it's 58 of our printed case where we've set it out. And it's paragraph 46 of the Court of Appeal's judgment.
Right.
And what we've then done at paragraphs 59 through to 59.15 of our printed case is look first at Europe, and we have illustrated how the stance adopted by 20 European states runs counter to the blanket prohibition in section 16.
It's probably not going to be very profitable for us to go through that. It speaks for itself.
Yes, I'm not going to, my lord.
If Ms. Stein wants to challenge any of it, you can pick it up.
Yes, we haven't heard any challenge to it so far. As I hope I'm accurate in the only submission that challenges our analysis of state practice is essentially about Mahamdia, what it says, what it was entitled to say, and so forth. We then address, having dealt with Europe, paragraph 60 to 65 of our printed case, what are perhaps the four other leading, or at least four other leading common law jurisdictions.
Yes.
Again, none of them supportive of a blanket immunity approach. And then at 61 to 61.9, we address the position in relation to countries ranged across Asia, South and Central America, Africa and the Middle East.
Yes, very well.
And there are a further 14 jurisdictions that we've gone through there. And the position that's ultimately arrived at is that the United Kingdom's legislative scheme, insofar as Section 16 is concerned, is out of step with the position reflected in either the domestic law or the international commitments of all 20 other European countries in relation to which material is cited. And it is out of step from further afield with countries as diverse as Botswana and Brazil, Israel and Iran, and the United States and Saudi Arabia. Now, against all of that, the Secretary of State has 2 points available to him in seeking to defend Section 16. First of all, he can point to the domestic legislation of South Africa, Pakistan and Malawi, each of which has legislation mirroring the State Immunity Act, including Section 16. And secondly, he can point to the fact that states have, as illustrated by the case law we've put together, from time to time been asserting rights to immunity, albeit for the most part unsuccessfully, and certainly even where successfully, not in a way which would assist in blocking a claim brought by an individual such as Miss Janah. Now, so far as the other legislation is concerned, South Africa, Pakistan, and Malawi, there are 3 responses available to Miss Janah, which we say deprive that legislation of any material weight in determining the correct outcome in this case. The first is that the legislation in those jurisdictions itself dates back more than 30 years, and at least so far as Pakistan and South Africa are concerned, was apparently introduced by what Professor Garnett has described in one of his other articles as a mechanical mirroring of the State Immunity Act. The reference there is Core Bundle 3, tab 23, MS 1678. The second point is that there is no case law of which the parties are aware in any of those 3 jurisdictions in which the equivalent provision to Section 16 has been tested. And given the constitutions of each of those jurisdictions, and which we've recorded in our annex to our printed case by reference to those countries, there must be at least scope for such a challenge, essentially on the same kind of grounds that this challenge is brought before this court, with the extra teeth to the Constitution that it's not simply declaration of incompatibility territory, but it's constitutional rights being supreme and inconsistent laws being void territory. And the references to the constitutional provisions are MS 350, MS 354, and MS 357. And the third point is that, at least so far as South Africa is concerned, it is notable that the South African delegate involved in the drafting process underpinning the 2004 convention was himself expressly opposed to a blanket bar on claims by embassy employees. This is a point we've touched upon already this afternoon, but as we've pointed out in paragraph 54.2 of our printed case, consideration was at one point given to 2 alternative lists of employees who could not bring claims, and there was overwhelming support for the narrower list, which would permit claims by most employees and certainly claims by service staff or domestic staff. And those comments included, favouring the narrower list, included comments from the South African delegate. And the reference to his comments are A19, tab 238, MS 6782, where he says, in terms, alternative B, the narrower list, was to be preferred since it was consistent with a restrictive approach to immunity. So back to our correct starting point and back to where that takes us in terms of correct destination. So there's nothing of substance that the Secretary of State can get from pointing to 3 other countries with equivalent legislation, so far as Section 16 is concerned. And that leaves us then only with the contention that the fact that states have been pursuing immunity from time to time, as we of course have to accept, given the comprehensive table we've put together, that somehow is a sufficient foundation for this court to conclude that there is a requirement in international law for Section 16. Now, we've addressed that argument without the benefit of Ms. Staines' helpful table at paragraph 62 of our printed case, and we make a number of points there. Firstly, as we say at 62.1, it is not inevitable that a head of mission's invocation of immunity in a particular case reflects the considered position in public international law terms of the state as a whole. Maybe an indication of that, but it's not inevitable. Secondly, it is telling that in contrast to the position adopted by Germany in the International Court of Justice in the jurisdictional immunities case, that none of the unsuccessful states in our table have considered it appropriate to take matters further. There's no evidence they've done so by way of diplomatic protest. They certainly haven't done so by reference to a claim before the International Court of Justice. And it's also apparent that some have not even sought to exhaust all avenues of appeal in the forum state where they first invoke immunity. Now, if the court can bear it, we're hoping overnight to put together a short counter table to the table we got yesterday. But the perhaps determinative point illustrating that table really takes the Secretary of State nowhere near far enough for the purposes of this case is the one that I started with this morning, and that is the point that there are only 2 instances on our reading of this table of someone in an analogous position to Miss Janah facing an invocation of immunity. And the 2 instances that we see as applying in that context are the Finland case on page 2.
It's this document that we got, is it?
It's that document, my lord, yes.
Thank you. This one.
This is the housemaid.
This is the housemaid. And then there's a gardener on page 3, Q8, claiming state immunity in Australia. Now, I'm not going to turn those up now, and we'll, as I say, if permitted to do so, put in a short note in response to this table tomorrow. But
Yes, that would help. I mean, if you want to add a column to the table, but if it's just 2 of them,
thank you.
much to whatever's convenient.
Thank you very much, my lord. But the short point is that in those 2 comparable cases, the state, true, asserted immunity at first instance, but didn't bother, having lost, pursuing it further. And that's a pretty inadequate basis, we say, for contending that there's some requirement of international law.
We'll look forward to seeing your...
Well, it's very kind, my lord.
I think I was so enthusiastic. I must have taken mine home, so maybe I could have a copy of the original.
I'm sure Miss Stain can give you a copy of the original as well.
I don't need it at this very minute.
Doesn't the Korean case refer to a domestic worker?
Which one, my lord, is that?
Page
That
4.
is the Korean-Australian one, I think.
Let's call it.
I'm sorry, my lord, I missed the reference.
Wait.
Domestic worker, it says.
Oh,
Park and Shin.
yes, and you may recall
Yes,
Park and Shin,
we do.
which was an unsuccessful claim in the United States, which did not go certainly all the way up the appellate tree in the United States. So I'm sorry for missing that out, and we'll make sure we don't. Yes, it's also the case that it was an assertion by an individual consular worker, not by a state. You may recall that there was a rather ambitious claim by the individual consular worker that he was to be treated as a state and could therefore benefit from state immunity. But the key point is that all of those claims failed and were not pursued on appeal further. So they certainly don't illustrate a particularly vigorous assertion or assertion carrying with it great conviction as to where state immunity lies. Now, the third point on this issue of assertions of state immunity, of course, and this I hope will be drawn out to the extent we can in the table tomorrow, is that because a state asserts immunity it by no means follows that it's asserting immunity by reference to a blanket entitlement. It might well be doing so, for example, by reference to an assertion on the facts that this particular employee was heavily engaged in the sovereign function, or that investigation of the claim would impact heavily on the sovereign function. And so one needs to be quite careful about
That was
simply...
the position in Sabah al-Lyle, was it not?
Yes.
I think that the suggestion was that the gentleman did have some involvement in the diplomatic side.
Exactly, and we saw that also in the NACU case that I showed the court this morning, where Sweden was focusing upon sovereign function rather than on a blanket immunity contention. So save, as I said earlier, save in that one respect concerning assertions of state immunity, and save in respect of Mahamdir, which I'll come to in a moment, we don't understand the Court of Appeal's analysis of state practice, or the way we put state practice, to be substantially challenged by the Secretary of State. He seeks to avoid it by posing a different test and having a different starting point and so forth. So that's state practice and the light it sheds on the requirements of customary international law. And it strongly favours our position, we say. The position of international courts and tribunals, including regional human rights courts, is also of relevance in the identification of customary international law. And we get that from the ILC guidance on customary international law at MS 5506, and in particular MS 5537 to 5538. And this is the point that we've made at paragraphs 63 through to 69 of our printed case.
Yep.
And as to regional courts, we of course have both the European Court of Human Rights and the Court of Justice of the European Union, in both cases at Grand Chamber level. And this is again a point that Professor Garnett makes in his 2015 article, that both those courts have arrived at the same destination of essentially applying a sovereign function test.
Yep.
Now, I've given the court a moment ago the references to the European Court of Human Rights seeing sovereign function as important in the context of its discussion of the 2004 Convention. And I'd like to go next to the Court of Justice and to the Mahamdir case. And the court has that at Core Authorities 3, tab 20.
Yep.
And the Court of Appeal addressed this at paragraphs 48 to 52.
Yes.
MS 444 and onwards.
Yes.
We have done so at paragraphs 64 to 66, MS 308, and the Secretary of State does so at 139, MS 247.
Yep.
And the Secretary of State makes what we understand to be 4 points in relation to Mahamdir, and it's a particularly problematic case for the Secretary of State because of its, what we say, is its binding effect. First of all, the Secretary of State says that the Court of Justice was not required to consider whether Algeria, the state invoking immunity in the case, as a matter of EU law, was entitled to claim immunity, as that was not a question referred to it, and so it was not necessary for resolution of the issues referred. That's 1391. Secondly, he says at 1392 that it was beyond the competence of the Court of Justice to address any issue of public international law. Thirdly, he says at paragraphs 139, 3 to 4, that the Court of Justice did not have sufficient materials before it to express the views it did. And fourthly, he says that the Court of Justice's view cannot represent state practice. Now, none of those points are of any substance. As to necessity for a decision on the point of state immunity, The Court of Appeal addressed this at paragraph 49 of its judgment,
Yes.
MS 445, and it cited in full paragraphs 53 to 56 of the judgment in Mahamdir,
Yes.
which you've got at MS 1561. And it concluded, the Court of Appeal concluded at paragraph 50, that in order to resolve the issue directly before it, as to the applicability of Article 18 of the Brussels Regulation, the Court had to consider Algeria's submission that customary international law precluded the possibility of the German courts having any jurisdiction at all. And the key passage, as cited by the Court of Appeal, is of course in the Court of Justice's judgment at 53 to 56. And at 53 to 54, you see Algeria's argument.
Yes.
At 55 to 56, you see the Court's observations as to the non-absolute nature of immunity.
Yes.
And you have the Court making two important findings. Firstly, holding that immunity could be excluded if the proceedings related to acts performed iurae gestionis, which did not fall within the exercise of public powers. And secondly, in the first, that's the last sentence of paragraph 55, and secondly, in the first sentence of paragraph 56, that customary international law concerning immunity did not preclude jurisdiction where an employee sought compensation and challenged the termination of his employment, where the functions carried out did not fall within the exercise of public powers, or where the proceedings are not likely to interfere with the security interest of the state. So it inevitably follows, we say, that the findings the Court made as to customary international law were a necessary stage in its disposal of Algeria's arguments under the Brussels Regulation. So the first point, that it wasn't necessary for the Court even to go into this territory, is of no merit. It had to, once Algeria was taking the point it was. As to competence, the submission that the Court somehow acted beyond its competence by even venturing into this area is a bold one, and it's wrong for three reasons. First, international law forms part of European Union law because the European Union is obliged to respect it. Now that position is consistently reflected in the Court of Justice's case law and is an entirely unsurprising one to arrive at, not least because of the observations my Lord Sumption made this morning about the general approach to international law and the Vienna Convention on the Law of Treaties and so forth. It's reflected in Mahamdir. It's reflected in another judgment of the Court which wasn't available at the time of the Court of Appeal hearing, which is in the Supplementary Authorities bundle at tab 264, so bundle 22, tab 264, SMS 132, and in particular SMS 139 to 40. And if I could just ask the Court to mark paragraphs 35 to 42 of that judgment, which makes it quite clear that the Court's approach is to apply customary international law because it's bound by it.
Yep.
What's the generally accepted name of this case?
Generally accepted name of that. Can I come back to generally accepted in this court or an international law?
Well, how is it normally referred to?
RBB against Evans.
Evans would be much easier, wouldn't it?
Shall we go for Evans, my lady? Yes.
Social Insurance Bank, I think, is what it's, how you'd translate
Right, my lady. Well, so the Evans case, it's paragraphs
Well, it's the
35 to
tribunal, isn't
42.
Yes, it's the tribunal.
Another example, in tab 263 of the same bundle,
Paragraph 2, it's the SVB.
I'm grateful to my Lord, yes, the SVB and Evans.
Well, cases always seem to bear more weight and authority when you know what they're called.
What's in the name?
The next case, my lady, which was in fact cited by the Court of Appeal at paragraph 52, is, I'll content myself with the Curragh case, which is at tab 263 of the supplementary bundle, and it's paragraph 18 of that. And that case law on the interrelationship between state immunity and the Brussels regulation has now led to the express reference in the recast Brussels I regulation to an exclusion of matters relating to acta iure imperii. And we get that from the recast Brussels regulation, which is in bundle 11, tab 83, MS 4490. And the one further reference on this point is again in our supplementary bundle from an academic commentator, Dickinson, at tab 265, where you see from...
Sorry, just before you go on to that, what provision of the Brussels recast is it?
It's Article 1.1, my Lord. My note is correct.
Yeah. When we got it to...
Yes, you see it's on page MS 4490,
Yes, I see, thank you.
and it's the last words of that provision.
Then we're looking at tab 265.
Now you're looking at tab 265,
Dickinson and line, yeah.
SMS 160, and paragraph 220 of Dickinson and Lean's book. And you see from paragraph 220, and then the footnote at footnote 46, the explanation that the Brussels I regulation was revised to make this point expressly clear, having regard to the case law, including Mahamdir and Curragh. So manifestly within the competence, manifestly necessary for a proper application of the Brussels regulation. And we say binding on the Secretary of State as a decision of the Court of Justice as to the scope of customary international law, or on any view, yet another powerful piece of evidence showing that the case that the Secretary of State has to make, doesn't wish to make because of his starting point, the case the Secretary of State has to make, that Section 16 is required by international law, is a hopeless one. Now, finally, on the question of competence, the only authority that's relied upon to suggest that the Court of Justice had no competence in this area is the Advocate General's opinion in the Laturitu case that was cited by Ms. Stein, and that doesn't assist the Secretary of State for a number of reasons. Firstly, it predates Mahamdir and Evans. Secondly, it consists at paragraph 78 entirely of assertion without any reasoning. Thirdly, the Advocate General had no regard to the obligation of the court to act in accordance with customary international law, which it must have had. And fourthly, the point, as articulated by the Advocate General, was not then adopted by the court in its judgment. So that's necessity and competence. And then the third complaint of the Secretary of State in relation to Mahamdir is, well, the materials before the court in Mahamdir weren't adequate. That's no answer if we're correct that it's decided what it's decided and it's binding. But in any event, it's not a good point. First of all, we don't know exactly how much material was referred to in the written observations before the court in Mahamdir. We do know that observations, and this is from the report of the decision, page 3, MS 1539, we do know that observations were received from Algeria, from Spain, from the European Commission, and from Switzerland. And we, of course, know, because this is the way the Court of Justice operates, that all other member states were entitled to appear in the proceedings. We also know that this was a decision of the Grand Chamber, so comprising 13 judges, each, one assumes, with very significant experience of their own legal systems and their respective member states. And that leaves only the final point that the Secretary of State makes, which is that Mahamdir is not evidence of state practice. And so far as that's concerned, our simple response is we don't rely upon Mahamdir as evidence of state practice. It's relied upon for three purposes. Firstly, as another example of a judicial decision illustrating quite how far outside the mainstream United Kingdom stance is. Secondly, because the International Law Commission has expressly recognised that decisions of international courts, including regional supranational courts, are a valuable source for determining the existence and content of rules of customary international law. And thirdly, because it is a binding authority on the content of customary international law insofar as it applies to European Union rights. The effect of Mahamdir is that the Court of Justice has now laid down what the applicable principle of customary international law is in the very specific context we are concerned with in this case, namely employment claims against embassies. And it is very hard in principle to see how there is any way around that for the Secretary of State. Now, it's true that Mahamdir was concerned with Article 18 of the Brussels Regulation, not with Article 47 of the Charter, which we're concerned with. But it's very difficult to see why a different approach should be taken in one rather than the other.
I suppose if there was a serious argument, which you say there isn't, about it being, as it were, paring curiam, the proper course would be for us to make a reference.
Yes, and that's the last thing we want. And
no, I'm not suggesting we want it, but
we certainly do say it's at Clare.
Yeah, no, of course.
I agree, my Lord, yes.
Yeah.
Could I just ask at this point, is it common ground between you as to which of Ms. Janah's claims are EU law derived and which are not?
I think it is, my lady, yes, and I think it's the race discrimination claim and the working time claims.
And the payment claims? Doesn't she have payment claims as well?
Perhaps you could get together if there's uncertainty.
The minimum wage claim is not an EU claim.
No, so it's not.
Do we have an unpaid? There is an unpaid holiday claim, which would be an EU.
Which would be, yes. Well, the only reason I'm asking is that were we to be with you and were we to be upholding the Court of Appeal, it would be good to know what the actual effect of any
yes, and there's no dispute
be.
between us on remedy.
It would be nice to know what it applies to and what it doesn't.
Perhaps you could let us have that.
Can I do that? I'm sorry for not being as precise as I should be.
If you could let us have that overnight.
But it's certainly the case that the order of the Court of Appeal in terms of remedy is not an issue on this appeal if we're otherwise right.
But it may be clear from the Court of Appeal's order. Yep. Okay,
We'll dig out the reference. I'm sorry for not having it.
No, don't worry. Yep.
So the final source in terms of international law, for the purposes of seeing how well Section 16 does, is the views of qualified publicists, as per the ICJ statute. And these we've addressed at paragraphs 70 to 75. of our printed case, and we say again they heavily favour the position that we contend for and the position arrived at by the Court of Appeal. And in response, the Secretary of State has cited a single lecturer, Dr. Yang, or former lecturer, I think I should say, and his assertions of enormous diversity and chiasmic divergences of view. Paragraphs 18, 136 and 141 are examples from the Secretary of State's printed case of observations of that kind. Now, we don't need to make any criticism of Dr. Yang's analysis because of the point I made both when intervening this morning and early on in my own submissions, that what we need to focus upon here is whether there is material diversity, and there is none. Dr. Yang himself correctly states that one of his core principles in his analysis is that states enjoy immunity for sovereign or governmental acts, but not for commercial or private or non-governmental acts, a position which is directly inconsistent with where the Secretary of State has to start his case. The reference for that is MS 1691. Secondly, the question, as I say, is not where precisely the line is to be drawn, or whether there is absolute uniformity of practice in all areas, but whether, even applying a margin of appreciation, the UK's position falls on the wrong side of the line. And thirdly, even if, which we say in fairness to him shouldn't be the case, even if Dr. Yang is to be read as supporting the Secretary of State's contention of material diversity, then he would have ranged against him the views of leading publicists in the field, such as Professor Garnett and Lady Fox, Professor Brownlee, Professor Crawford, Professor Wilmshurst, and the overwhelming weight of the other state practice, legislative and judicial material that we've pointed to. So that is section 16. Section 42B next, if I may, and that is addressed by the Court of Appeal at paragraphs 54 to 66, by the Secretary of State at paragraphs 111 to 123, and 142 to 151, and in our printed case at paragraphs 80 to 115. Now, we have summarised at paragraph 80 of our printed case the Court of Appeal's findings on this issue. And again, the same question: can the Secretary of State show that a provision such as section 42B is required by international law or reflects generally accepted rules of international law? And as we've sought, having set out the key findings made by the Court of Appeal, as we've sought to draw it together at paragraph 81 of our printed case, the correct analysis and the correct answer to those questions can be summarised, we say, in two propositions. Firstly, there is no requirement in international law for a provision such as section 42B. And on the contrary, a term of its breadth and reach breaches the prohibition in international law on discrimination on grounds of nationality. And secondly, against that background, the provision has to be held to breach both the European Convention on Human Rights and the Charter, the EU Charter. Now, as to the first of those points or propositions, no requirement in international law for such a provision, and to the contrary, a breach of the international law prohibition on discrimination by such a provision, we make paragraphs 83 onwards what I think boil down to 6 points. Firstly, there can be no doubt, and there won't be any dispute about this, as to the high standing of the prohibition on discrimination on grounds of nationality. It's reflected right across the piece of international human rights instruments. Secondly, this is, of course, a critical stage in our argument, bringing us back to the specific context of this case. As long ago as 1999, those involved in the drafting of the UN Convention recognised a provision which was the direct analogue of Section 4.2b to breach the prohibition against discrimination on grounds of nationality. Now, this is something which the Court of Appeal describes at paragraphs 59 to 60 of its judgment. And as we pointed out in paragraph 88 of our printed case, the IALC working group, first responsible for this view, included in its number international lawyers of the highest distinction. We've referred to Professor Brownlee, Professor Crawford, and Professor Hafner. Professor Dugar was also a member of the committee, of the group. And it's also worth emphasising in this context that the conclusion that the provision equivalent to Section 4.2b should be deleted was endorsed both by the International Law Commission and by the General Assembly's Sixth Committee. And as I emphasised earlier, the Sixth Committee is the leading legal body of the General Assembly, upon which all states are entitled to representation. And the reports of both the ILC and the Sixth Committee were then expressly highlighted in a General Assembly resolution. Now, we get each of those points from the O'Keefe summary at Core Bundle 3, Tab 25, MS 1768. And so far as the ILC is concerned, from MS 6707, and so far as the Sixth Committee is concerned, from MS 6699 and 6720. So that's the second point. Almost 20 years ago, those most involved in looking at the proper reach of state immunity and the proper balance in terms of nationality and so forth, considered that the Section 4.2b balance breached the prohibition on discrimination. The third point is, and it follows from that deletion, and this is our printed case, paragraph 86, that the UN Convention, of course, would not bar a claim in the manner of Section 4.2b. So if the court were to conclude that the UN Convention was indeed to be treated as an authoritative source of customary international law, then that would be fatal to the Secretary of State's position, because it would show that a restriction imposed by the State Immunity Act was not imposed or required by customary international law. And it's in any event highly persuasive material. The fourth point is that neither the Court of Justice's approach nor the Strasbourg Court's approach support any argument that Section 4.2b represents customary international law or is required by it. As we've seen, the Court of Justice proceeds on the simple basis of sovereign or non-sovereign determination of immunity, Sima Hamdia, and the European Court of Human Rights proceeds on the basis that Article 11 of the 2004 Convention represents customary international law, or, to give the Court of Human Rights approach the benefit of Professor Garnett's analysis of what they've done, it too proceeds essentially on the basis of a sovereign versus non-sovereign distinction. The fifth point on this is that, so far as state practice is concerned, the Secretary of State can do a little better than he was able to do in relation to Section 16, but not very much and not materially better. He can still point to the mirroring legislation from Pakistan, South Africa, and Malawi. And so far as an analogue of Section 4.2b is concerned, he can also point to the law of Singapore, the legislation, I should say, in force in Singapore. He seeks to rely, in addition, on the legislation in Israel and Argentina, which has some similarities, but as we've explained in paragraph 101 of our printed case, when you actually look at that legislation, it would not bar a claim of the kind brought by Miss Janah, because it focuses on a critical and different point in time, namely nationality and residence at the time proceedings are commenced, rather than at the time when a contract is entered into. As to Pakistan, South Africa, and Singapore and Malawi, we have the same point as I've already made. The legislation dates back to the same era as the State Immunity Act, and it is yet to be tested in any court proceedings in those jurisdictions. So that's the fifth point. In terms of state practice, there's only that very small body of legislation which the Secretary of State can pray in aid, as yet untested by litigation, and there are no judicial decisions. And the sixth point is that all of the leading academic commentators to express a view in this area have expressed the view that Section 4.2b is discriminatory and needs to be amended. Now, we get that from, albeit wearing different hats, Professor Brownlee and Professor Crawford, as a result of their membership of the 1999 working group. We get that from Lady Fox and Dr. Webb in their leading text on state immunity, which the Court of Appeal cited at paragraph 65, and in respect of which we've cited the same conclusion in the latest edition at our printed case, paragraphs 96 to 97. We also get that from the views of Professor Wilmshurst and Joanna Folkes, one of the leading academics in the field of state immunity. Their views were one of the materials upon which Fox and Webb had relied, and we get their views set out as long ago as 2005 in a Chatham House paper, which we've included in the additional bundles, the supplementary bundle, the very last tab of those at SMS 165. And this is a paper analysing the convention. And on the fifth page of that paper, and it's analysing it by reference to the State Immunity Act, we get Professor Wilmshurst and Ms. Folkes expressing or stating the convention differs from the UK Act in that it does not permit the foreign state to retain immunity simply because the employee is a third country national and not habitually resident in the state where legal proceedings take place. The provision in the UK Act seems discriminatory and inconsistent with the United Kingdom's international obligations under the European Convention on Human Rights, in particular the obligation to afford a right of access to court. Now, for what it's worth, and back to a point we touched upon earlier, we haven't found any evidence in any of the commentaries which address the convention, including Wilmshurst and Folkes, supporting the contention that the Secretary of State makes about 11.2b4 that I was making submissions on earlier.
But Mr. Otti, have you really addressed the what I understand to be the rationale behind Section 42B, a legitimate rationale in international law, as I understand it, namely the local labour force really shouldn't be precluded by state immunity from asserting its rights in the forum. You're going to deal with it?
I am.
Very well.
I appreciate I haven't addressed that, but I'm going
Very
to.
well.
The reason I focus, my Lord, on required by international law is that it was the stated purpose of the State Immunity Act. And that is the test that the Secretary of State has to clear for Section 16 and Section 42B to pass muster. It's not enough, we say, for the Secretary of State to say, well, the question of nexus is important and it's legitimate to have regard to issues of nationality, issues of residence and so forth. What's important and what's material in terms of the definitive test here is the balance struck by Section 42B one that is required by international law, accepting that there must be a margin of appreciation in that analysis. But that's why I start with the question of what is required by international law. But I'm certainly not shying away from the nexus point.
Very well.
And we say we're right on it too. Now, before getting to that, if I may, if I can just complete the survey of international law materials on this issue, the Secretary of State does quite understandably, in this context, rely upon the Bâle Convention, because the Bâle Convention contains an equivalent provision to Section 42B. And so the argument goes, well, if it's in the Bâle Convention, how on earth can it be outside the range of tenable views? Now, we've addressed the Bâle Convention in this particular context at paragraphs 98 to 100 of our printed case, and to some extent the points I've made there are ones that I've already addressed, but I would like to emphasise them, if I may. The first is the obvious one, so far as this case is concerned, that the Bâle Convention contains no relevant obligations at all in relation to Miss Janah's claim, as the Court of Appeal found at paragraph 56, because quite obviously Libya and, in Miss Benkharbouche's case, Sudan are not parties to it. So in terms of strict treaty obligation, it doesn't contain anything relevant.
Yep.
Secondly, and perhaps more importantly and substantively, it is not treated by even the other signatory states to it as reflective of customary international law. And that's the point we make by reference, or at rather.
Those cases in paragraph
100, exactly so, 100.1 to 100.6, where we've dealt with the other jurisdictions.
For my part, subject to anyone else, we'll hear what Mr. Taylor says if she challenges what you say. But I'm happy to take them as read, unless there's anything important, there's anything specific or important in any of the judgments.
There's one of them I'd like to show by way of illustration, my Lord, if I may, and it's an Italian case involving Zambia, and it's at Authorities 17, tab 202, MS 6282.
Is that in your list of paragraphs 100? That doesn't matter.
6282.
No, I'm afraid it's not in the 100 list of 100. It's another example, I think, of the Italian.
You've got to take it. Yes, okay. Thank you.
Do you say 6282?
Yes, you did.
Sorry, 6090, I'm sorry. So it's A16.
Zambian Embassy and Tanzania.
6090 to 6091. And so it's another case of
well, is it all in the head note? Is
point
it all in the head note?
it's in the head note, and then it's really, I mean, it's a very short judgment, but on the second page, it's the last paragraph, where the court is emphasising the critical importance of equality and the right of access to the courts. Now,
That's essentially a decision based on the Constitution, isn't it?
it is, my lord, yes, and within it, the constitutional prohibition on discrimination.
Yeah.
Now,
So you say it's this, and it were the same animal in different clothes.
exactly so. Now, you've seen from the table at the end of our printed case that we've sought to go through all of the country materials that are available
Yes.
in this area. In some cases, there is express emphasis on the importance of equal access to justice, such as the example I've given. In most cases, there doesn't appear to be any reference to considerations of residence or nationality as being particular importance, and the critical question is sovereign versus non-sovereign. So we end up in a position so far, and I'll come now well, I'd like to go to A and others and the correct approach to discrimination analysis first, and then to the nexus point, if I may. But so far as the Basel Convention is concerned, we end up in a position where it's obviously not relevant as a simple treaty obligation, and there's no requirement as a matter of simple treaty obligation for Section 4.2b. And we also have the fact that every other state signatory to the Basel Convention has said it doesn't represent customary international law. So there's no obligation as a matter of customary international law. So I appreciate nexus needs to be addressed, but as a matter of strict analysis, where both in terms of the stated purpose of the State Immunity Act when enacted, and in terms of the Strasbourg Court's analysis as to the relevant question, the relevant question is this provision required by international law? And the answer is no, it's not, because there's no source of international law that the Secretary of State can point to, which shows that it is. So the next area that I wanted to go to is to discrimination itself, and within the context of that, to look at the question of nexus.
Yeah.
As to that issue, the Court of Appeal addressed it at paragraph 61 to 65, and we've done so at paragraphs 103 to 110. And the first authority I'd like to take the court to is A and others, the Belmarsh case and the speech of Lord Bingham for the structured approach. And that was also the authority we relied upon before the Court of Appeal in particular. And that's at Core Authorities 1, tab 7, MS 916.
Where do you want to go?
I'd like to deal with the speech of Lord Bingham from paragraph 45 onwards. Which is at MS 960 under the heading discrimination.
Yes.
And at paragraph 46, Lord Bingham emphasises the importance of the principle of non-discrimination, citing Professor Lauterpacht over the page at 113A to B, and then citing Lord Hoffman in Matadine and Pointu at D to E.
Yeah.
At 48, he cites the fundamental importance of aliens within the jurisdiction enjoying equal protection, referring to cases as far back as Khawaja and via Khawaja Somerset's case. At 49, he cites the European Court of Human Rights decision in Geigershuis for the unsurprising proposition that against that background, very weighty reasons are required before any justification for differential treatment based on nationality can be upheld. And at 50, he then sets out on, particular over the page, at page 115 or MS 963, he then sets out the structured approach which the Court of Appeal would itself cite at paragraph 61.
Yes.
And the central question is that set out by B, whether persons in an analogous or relevantly similar situation enjoy preferential treatment without reasonable or objective justification for the distinction.
Yes.
And he then shows at D to E how that can be broken down into the five questions.
Yes.
Now, before leaving that authority, I'd also like to ask the Court to note paragraphs 55 and 56,
Yes.
because of the Attorney General's submissions there, and the Attorney General's reliance upon Mustaqim, Agee, and Mawia, three of the authorities that the Secretary of State relies upon in this context against me, and then Lord Bingham's response to that in the last sentence at paragraph 56, where he correctly characterises each of those cases as involving immigration questions where differential treatment on grounds of nationality will inevitably and materially arise, and says that the relevant question is whether and to what extent states may differentiate outside the immigration context. Now, addressing Lord Bingham's 5 questions in the discrimination analysis here, we say they all fall to be answered favourably to Miss Janah for the reasons given by the Court of Appeal. And going back to the 5 questions, they're on page MS 963. Firstly, the facts fall within the ambit of Article 6 of the Convention. Secondly, and this is addressed by the Court of Appeal in paragraph 61 and following. Secondly, there is a difference of treatment between the claimants and others who can be put forward for comparison, namely UK nationals seeking to pursue similar claims. Thirdly, and this is common ground, that difference would be based, at least in part, on nationality. And the two groups must, we say, be treated as analogous, because the assumed premise for the debate is that their working arrangements are identical, that they have no connection, and this is the beginning of my engagement, if I may put it that way, with the nexus question. They have no connection with the employer state beyond their employment relationship. There's no question of Miss Janah being a Libyan national with some particular citizenship tie of that kind. And thirdly, in each case, for the reasons I've been seeking to submit already, in neither case does international law require immunity to be granted. And then against that background, the fifth and final question, there can be no reasonable or objective justification in the sense that the differential treatment had a legitimate aim and bore a relationship of proportionality to that aim. And in that context, it's not enough to bridge the gap from restrictive measure to legitimate aim to say some other people do it this way. Because the legitimate aim here is compliance with international law. That is the only aim identified by the Secretary of State in respect of Section 4.2b. As the printed case says, the Secretary of State's printed case says at paragraph 24, the State Immunity Act was enacted to ensure that the United Kingdom's domestic law gave effect to its international obligations. And that was exactly the same position that was adopted entirely correctly before the Court of Appeal. Now, at one level, one could stop the analysis there, because on the basis of the materials that I've shown the court, there is simply no requirement in international law for a provision of this kind. And it does not...
But if international law has rejected it on the basis of discrimination, then you've got to delve into discrimination. And you've got, because justification would negative it.
My Lord, yes. I've got 2 points, essentially. One is there's no material to show a provision of this kind to be required by international law. And it's even clearer than that, because actually this provision breaches the prohibition on discrimination. So it's an extra string to my bow, is the way I put it. So there's no requirement in international law for a provision of this kind, and it doesn't reflect generally recognised principles of international law, because all we've got, by way of reflection of this, are those very few examples of legislative mirroring, and that's nowhere near enough. Now, I'm quite happy and intend to delve into the question of discrimination further, because I do say it further supports my case for the reasons that the Court of Appeal gave.
Where do they give their reasons?
It's 65, I think
65,
it is.
thank you.
Section 42B begins, the consideration of Section 42B begins at paragraph 54, you then get the consideration of, in particular, the rejection of the earlier draft, which had the analogue to Section 42B at paragraph 59, where reference is made to the ILC working group and the Sixth Committee. You then have our submission by reference to A and others in Lord Bingham's speech at 61, and the analysis of, or the treatment of that submission from 61 through to 65, and the conclusion reached at 65 that Section 42B is indeed discriminatory on grounds of nationality, and an indication that the Court of Appeal was fortified in this conclusion by the ILC working group's view and by the views expressed by Lady Fox and Dr. Webb. So those are the key paragraphs in the Court of Appeal. As I say, and as is apparent from that, we relied principally before the Court of Appeal on A and others. I wanted, if I could, for the purposes of the present argument, to rely upon 2 additional authorities on the question of proportionality and justification for differential treatment. And those are the cases of the recent case of this court of In re Brewster and the Court of Appeal's decision in the Public Law Project case, which was overturned on the vires point but left untouched on the discrimination point. Both of these are in the supplementary materials bundle. Brewster is at A22, tab 258, SMS 4. And the important point really to draw from this, and the reason we rely upon it, is that it draws together the guidance of the court, in particular from my Lord Wilson, Lord Sumption and Lord Reid in the Quiller and the Bank Mellat cases. And it's paragraph 66 where the test for proportionality is addressed. This is MS page 25, page 540 of the internal numbering of the judgment. And there are 4 stages that are there set out. Whether the objective of the measure is sufficiently important to justify the limitation of a protected right, whether the measure is rationally connected to the objective. And 3 is the most important one for my purposes, whether a less intrusive measure could have been used without unacceptably compromising the achievement of the objective. Now, the obvious point here is that we know from the 2004 Convention, which the United Kingdom has after all signed, albeit not yet ratified, that a less intrusive balance can and has been struck, and that less intrusive balance can and has been struck specifically by reference to the prohibition on discrimination, as evidenced by the views of Professor Crawford and Professor Brownlee and the rest of the 1999 working group. And so, if one does delve deeper into the question of the proportionality analysis, we get to the same outcome, which is that Section 42B is not capable of passing muster, either for the purposes of the broader is it required under international law test, or for this more specific discrimination analysis for the is there a less intrusive means available test. And the additional authority on that, which we say lends further weight to this, is at the very next tab, and it's the public law project case of the Court of Appeal. And it's tab 259 of this bundle SMS 27.
Yes.
And the particular point we emphasise from this judgment is the emphasis that the Court of Appeal gave to the need for particularly intense scrutiny of allegedly discriminatory measures concerning access to court.
Right, where do we find that? Which
You
paragraph?
find that, my lord, the material paragraphs start at paragraph 30,
Yep.
and those that are of particular importance for my purposes are paragraphs 35 to 38, and then 44 for their application to that case by reference to the case of ex parte Witham.
We'll look at that. Thank you.
I'm grateful, my lord. Now, this case too, of course, is concerned with the fundamental question of access to the courts. And so on Lord Justice Law's approach, it calls for particularly intense scrutiny. And the analysis that Lord Justice Law's adopted, as you will see there, was to identify the obvious suspect categories of discrimination, nationality, race, gender, and so forth, but also to say that suspect categories were not limited to those. And there would be some categories of subject matter which would also trigger the intense scrutiny required by the suspect classes, of which access to justice was the most important for those purposes and for mine. And this chimes with a point we'd already made, citing Lord Hope in Kebeline in relation to the high constitutional importance of access to the courts at 23.3 of our printed case. My lord, in terms of timing, I'm doing quite well, and I'm quite confident I will finish within my allotted time
How
tomorrow.
much more have you got?
I've got a little bit more, because of the importance of the case, I'm a little reluctant to sit down too early in case I've missed something that my junior tells me I shouldn't have missed overnight. But I'm certainly happy to press on, but I wouldn't be confident of finishing tonight, and I think I might assist more tomorrow.
The message I'm getting is that if we give you time to regroup overnight, it might be a more efficient use of time. Is that a fair way?
I think that's fair, my lord, yes.
Well, in that case, we'll resume again at 10 o'clock.
Thank you very much.
Thank you very much indeed. Thank you. Oh, now, Joe.